All right, everyone. The GOP in Colorado has now referred their particular complaint against the Colorado Supreme Court to the SCOTUS, and so they now have the opportunity to weigh in on yes or no, you're allowed to keep Trump off the ballot under the auspices that he committed insurrection, and insurrectionists aren't allowed to run for office. Even though this is literally just the primaries and has nothing to do with the general election, which would fall under more general state purview. Here's what I think will happen if SCOTUS is wise. Right now, a stay is issued on the order. The Colorado Supreme Court effectively said, we find that he's ineligible, but we want SCOTUS to affirm that fact. Otherwise, you know, we're putting our own decision on hold until that further consideration happens. SCOTUS, therefore, has a way out depending on what other states do in their decisions. If a state decides to issue this type of decision and does not put it on stay, it will force SCOTUS' hand. So long as they are indefinitely stayed pending a decision, my understanding is that SCOTUS can literally just sit on them and refuse to respond. They can simply say, well, we got bigger things to do, whatever. There's an indefinite hold on the decision, so it doesn't take effect. So Colorado will still have Trump on that primary ballot. By the way, the GOP there is saying, well, if no one weighs in or if there's no amelioration, we'll just switch to a caucus. We'll say, fuck it, we'll just bypass the Colorado Supreme Court. We won't have a primary. We'll do it ourselves completely and take it up in our own hands, and we'll just bounce the primary entirely and not have it. That would be interesting. By the way, I mean, Ron DeSantis probably out by Colorado, but he'll probably do better in caucus states because he's more that rural candidate sort of thing, and that tends to help during caucuses. But then he'd probably have 2 points of support, but for what it's worth, he got 2 instead of just 1. I think that that's what SCOTUS should do. I think that if no other state issues a decision to try to keep him off without staying the decision, so long as that's the case, I mean, the primaries still go forth. No decision is actually needed. The problem with SCOTUS weighing in on it is that if they're not very careful in the decision and the language that they use for that decision, they could create a legal precedent that could be problematic, because you could either side against Trump, which means you're saying that perpetually state Supreme Courts are capable of unilaterally deciding that a state with a primary is not allowed to have a candidate for literally any reason they want. Because Trump was never charged with or found guilty of insurrection, that's not the underlying basis for the decision. Effectively, the decision was just, it's our opinion that he committed insurrection. Yeah, there doesn't need to be a legal case for us to keep someone off the ballot. Don't you see how that could be a little problematic? So that's one end. Or they could side with Trump. But if they're too expansive, then you're saying, well, former presidents are effectively above the law. They can act with total impunity. A president can embezzle money, commit fraud, and defraud people, etc., and you can't do anything about it. Would that extend to violent crimes? Former president goes completely apeshit once they're out of office. They just go bonkers for no reason. They having a really bad day. They kill their spouse and their kids and everything else. Can you put them in prison? SCOTUS would, at the very least, SCOTUS would have to make it clear that it's only the situational, singular application of the Insurrection Act to Trump in that specific case. I mean, the way to do that is easy. Just say, well, he has never been actually found guilty of insurrection. He was put on trial by the House for fomenting insurrection, but he was acquitted by the Senate. And there was no further case on that topic. The other charges against Trump don't fall under the Insurrection Act, and so it's not applicable. If they use that kind of language in a decision, and they probably should decide, and I hope that that would be their decision, then no harm, no foul. They're just simply saying that this particular case is not applicable under that provision, under that constitutional provision. My worry always, though, when SCOTUS takes up a case is that they'll be too broad, because they often are. Sometimes they don't go broadly enough, like with Bruin. They issue a decision that seems pretty straightforward and cut and dry, and now the states are unilaterally ignoring it, like the latest case in Massachusetts in federal court, where no case law was even cited for the judge's opinion. That should definitely be taken up by the Supreme Court as well. Reaffirm and reassert yourselves and say, no, if you can't cite any bit of case law that actually coincides with your opinion, then it's just literally your opinion, man. We're striking down these rules because they're nuts. Oh my God, you can establish a legal precedent going back to the 1970s in most cases at earliest for most of the gun control being applied in the states today. Well, the founders weren't around in the 1970s. They were in the 1770s. That appears to be a little bit of a gap of time now, doesn't it? You have to go back to the 1870s before you have any gun control at all with the Cruikshank decision. Of course, that wasn't very expansive at the time. That was just the Klan's way of being able to lynch black people and hope that they weren't going to have an illegal firearm to shoot back with. So SCOTUS, I think it's pretty likely they will weigh in. My hope is that they will narrow their language. So don't leave it open-ended, actually. Leave it for a future incarnation of the court to hopefully do the same thing and find whether situationally the Insurrection Act or something else would apply. Because otherwise you could have any candidate for any office. Simply the judge says, it's my opinion that you engaged in sedition, and so you're not allowed to be in this primary. You're not allowed to be on the ballot. No case law cited, so it doesn't matter. You didn't even need to be charged with it outside of the halls of Congress with a partisan house, again resulting in acquittal. So, I mean, and that's not even a criminal proceeding. That's legislative. That has nothing to do with the court system in the criminal or civil sense. So it's, again, it wouldn't necessarily be applicable. SCOTUS should consider it, and they should side with Trump, but do it narrowly and do it situationally. That's my big hope. That's about all. Peace out.